Еще раз доброе утро.
Once again, good morning, colleagues, friends. So we were waiting to start. We were waiting till the engineers start streaming our session on the internet, and we are here today to discuss a very important topic, which is strong legal protection today and new methods of legal protection of technological advancements and achievements. So the topic is phrased a little bit in a very strange way, because of course we are very much used to the idea that there are results of intellectual activity, and there are legal protection laws, and there is a special article on the protection of useful models, software, and other intellectual products. This list of intellectual products includes 17 or 16 or 17 products, and when we check legislation from other countries, we see that that legislation is more detailed, and they use different wording for the protection of intellectual property rights. When we compare Russian legislation on the protection of inventions and compare it with other countries, say with US legislation, they use other definitions for the protection of intellectual property rights, the invisibility, the level of inventions, and certainly there is a difference in the two or many types of legislation. And then from technological inventions, we go over to computer games, music, television, and these sectors have their own intellectual property products. Earlier on, we watched a film and we saw and we listened to a soundtrack, but now the production of a film is much more complicated when a tune is combined with lights, with computer graphics, and that means that the list of intellectual products is gradually increasing. So we are going to look into the future and analyze other sectors, for instance, genetics, additive production, gene editing, and these spheres of life produce even more complicated, more complex intellectual products, and they need relevant legislation, not the one which was formulated in pre-digitalization era. We have to protect 3D prototyping or gene editing, and these intellectual products needs another type of protection. It's necessary to interpret these inventions in legal terms. Industrial designer creates a 3D model, and then we want to patent it as a useful model. And this useful model is only a two-dimensional model. So can we judge the efficiency of this invention when a 3D model is interpreted in a 2D context? Can we protect a 3D model using a 2D legislation? So it's a question mark. And I think that our major task today is to discuss how we can work out a stronger legal protection today. How can we protect legally artistic and technological advancements? We're not going to separate artistic achievements from technological achievements. The modern world is so complex that it's so difficult to separate one from the other. Sometimes technologies look like art, and art looks like technologies, and sometimes they coexist, and sometimes something that is produced in art is becoming more useful and indispensable of our everyday life. So we are going to look at artistic and technological achievements to define the specificity of intellectual products, and we're going to discuss how we can protect our intellectual property rights in court. So this is how I see today's session, and if you have any additions, any comments, please welcome. And after each intervention, I will ask our panelists questions, and I'm more than happy to welcome everybody who would want to take the floor from the audience. And we're mixing art and technology. So I'm just looking how to approach this topic. And let us start with probably art. Art is let's start with technologies, and the floor is given to our first speaker, Natalia Belinka, Roscosmos State Corporation, and I will be introducing all speakers. Natalia spent a lot of time in Roscosmos, and she is Rosatom, and she was the one who invested a lot of effort into education management and intellectual property management systems. So we are speaking about the application of these technologies, IP technologies, in the sphere of your activity, professional activity. Thank you.
Distinguished colleagues, may I take a seat? Good morning, distinguished colleagues. I liked the term pre-digital epoch. It's very it exactly reveals what we are discussing here. And 2 or 3 years ago, we met and discussed quite simple things: how to change the legislation and how to change some regulations of our legislation, and how to invest some new meanings into the legislative sphere that we are regulated with. Now we are introducing, or we are entering a digital epoch. And I think that the legislative framework does not reveal all the necessities of our new digital epoch. So it's not only about imperfection of our legislation, but it's about just some conditions in which we work in some public sector and how they coincide with the new challenges. The technological epoch and technological environment is not so flexible to adapt to the, or just the legislation is not so flexible to adapt to the digital environment. So we built some new power stations. While working in Roscosmos, I cannot accept the term. I cannot accept that our environment is much more difficult or much more simple than, for example, the art environment. So it can be both. And the intellectual property in Roscosmos is quite complicated. Yeah, so just we are used to working with some particular terms, and we are used to working with icebergs, where you cannot see some particular meanings which are below the sea level, and sometimes you cannot even identify them. These are new objects of intellectual property rights, and we identify them as new objects of copyright. These are the, well, creative works, the documentation, the the rockets design, and some informational models that we work with, or some merged rights. So just the zoning and screening of the land surface that we reflect as the pictures. Just when we get the picture, what the Earth looks like when we do the screening. So just when we do the screening of some particular places on the planet. So we try to identify these objects within the legislative framework, and but there are so many elements, more than 10,000, the elements which must be stated and must be identified by the civil rights protection legislation, by the legislation. So, and there are no universal instruments. We are trying to design something new. If 1225 was comprehensive, as it is in, just in other countries as it is in the world, that would make our work probably more simple or more difficult, because unfortunately we haven't identified these objects yet. And sometimes it's complicated to identify the objects. To a larger extent, it turns that we have the results of intellectual activity. We are used to having the results of intellectual activity, and we can have them in digital form, but we can hash them, we can hashtag them, and then we can prove that this, yes, that object was created on some particular day. But now we are in the situation when every second we create some object which must be protected by the intellectual property rights, and this object may be changed every second, right? So just we cannot fix its particular shape or its particular original look. Yeah, so that's right. 2 years ago, we didn't even discuss whether it is necessary to protect the intellectual property rights in this field. But now, just we speak about the same norms, and it requires some particular regulations, and these regulations cannot be found in the traditional legislative framework. Well, we can make up some new legal constructs, and well, just we. But of course, we understand that it's the intellectual property, and we need to protect it. So that's the understanding that we are coming to right now, and we understand that it's very, very flexible. It's changing every second, but as soon as you declare it to be information, and then you will require some service to well, just of mapping, so then to get the access to the information, then you will be speaking about the VAT. Yeah, so just, and what would be your profit? So you say that our talk is broadcast, right? Yeah, so just we want to see our profit, and our profit and benefit could be in the essence of what we are doing. And proceeding from what we have said, well, Vladimir, if you speak about the informational models, I think that it would be another story from the nuclear sphere, nuclear field, that can be also discussed. Yeah, so we discussed with colleagues the informational model of nuclear power station. It can be seen from 4 different angles. Well, because of the purpose, because of the application, because of the development and so on, design and so on, different programs, different software, and yeah, and I think that Vladimir Maslov, the counselor to the Department of Innovations of Rosatom. So just you have the objects which are qualified as what? Good morning, dear distinguished colleagues. So we have very little time, and I have very little time to speak, so I will use, well, just something that I have prepared. So just we are speaking about the intellectual property, and I'm going to speak about our corporation attitude to all these issues. So the most important, Vladimir, is to concentrate on our topic, to focus on our topic. No, I'm not sure that I can do it right now, well, because I was getting ready for a little bit different thing and a little bit different discussion. So Rosatom proceeded from the point that Russia must be the deliverer of the innovative products with high VAT rather than raw materials or technologies, and our corporation was going to become the corporation of knowledge. When we were working out the system of knowledge management, we wanted to identify the knowledge, to formalize the knowledge, to identify and protect the results of intellectual property, then to transfer technology and intellectual resource. In this slide, you can see what Natalia Belinkaya was speaking about. You can see the digital visualization of the infrastructure of nuclear knowledge from the original moment, from the moment of launching the nuclear power station, and through the whole life cycle of nuclear power station. This slide, no, the next one, yes, this. In this slide, you can see the cooperation of the system, or within the system of knowledge management within the corporation. So just it's intra-corporation as well as inter-corporation management. And here you can see the digital integrated solutions for the knowledge infrastructure. Today, nuclear knowledge infrastructure includes 25 instruments, and you can see them in the right side of this slide. This slide shows you the example of our, new suggestion for the novice countries which are going to develop the nuclear technologies to transfer the knowledge or to transfer the knowledge system. In this slide, I have to say, first of all, that a major stage in the system of knowledge management is is the developing of IP portfolio. And how do you see that? So you see that IP portfolio includes several stages, and it shows the cooperation between the developers of intellectual resources and IP operator who is included in the corporation structure. And so just it results in the know-how portfolio and the final portfolio. Then you can see the first stage of developing this IP portfolio. First, we develop BIP, so that is the intellectual property which was created on this particular project before, or an object before. Then we structure it. Then we structure this portfolio on different nonsense solutions, and then we develop the roadmap how to just work with this portfolio further. We all know that when we develop the actual IP portfolio is the background for intellectual property protection. And you can see the evolution, the development of IP portfolio on water nuclear reactors, which are produced by Rosatom. And so just you can see all the stages from the very first stages on infrastructural development until launching the reactor into practice or into action. So, and you can see the just all the stages, and actually the portfolio makes it possible to expand into the foreign markets. Clicker doesn't work all the time. Can we change the slide?
Слайд переключить, потому что по-другому не получается. Только 10-й. Наверное, это самый важный слайд.
Да показывали же 11. Переключите, девушки.
Ну, видите,
Самый важный слайд.
самый важный, видимо, был 10-й.
Нет, самый...
So please make it possible to see the 11th slide. Well, probably the 10th was the most important. No, the 11th was the most important. It was 11th. Can I have the 11th slide? So I can make the clicker work, probably. So here you can see the results of application the patent strategy. The patent strategy with the to the knowledge management and to digitalization of the knowledge. So you can see just that the results of this strategy make up about 20% of all the patent activity in Russia. And now our corporation has got more than 20 patent with foreign patent agencies. So just you have mentioned several very important things for our current discussion. You said that there are about 25 information systems in Rosatom which accumulate knowledge in this or that form. And you have even mentioned some things like digital twins, 3D models, 3D models of power stations. And then you say that out of these systems, you can develop some regimes, some regulations of patent protection. So it means that the knowledge which is accumulated by the corporation can be introduced in some certain formats, some certain special formats, and only when you come further to the foreign market, you develop it into some accepted or some traditional forms. So can we get back to slide number 6? Yeah, you can see in the right-hand side of the slide that all the infrastructures and all the infrastructural elements. Yeah, so just here you can see fewer than 25 because some of them can be split into several. And you can see in the right-hand side the instruments which have already been developed and which we apply to our current work. And so we use it to create, to develop, and to protect IP portfolio. Yeah. Especially when we come to the foreign market. And that's, well, actually everything. That's the whole life cycle. So just it covers the whole life cycle. So the system of knowledge management covers the whole life cycle. Yeah, so.
So I have a question, and I would like to invite Lukashin Alexei, St. Petersburg, Peter the Great, St. Petersburg Polytechnic Institute. Now we are passing over to another topic, IP portfolio, similar to the one that Rosatom described us when Rosatom wants to have some patent decisions, and we are now going to speak about this transition period when we actually translate knowledge into the form of a patent, which will be submitted to the patent authorities. And we have to speak and think about the practical application of this patented inventions. Do you think it's easier to have this inspection and evaluation of the invention where it is done? Peter the Great Institute is very famous for its digital tools, Cortege project, which is a digital project, and neural networks which are absolutely applicable to digital models. Thank you. Do you think I can have my presentation on screen, please? So in 2017, 2018, we were lucky to take part in a project on the creation of platforms for 3D platform comparison, which can be applied to both art objects, to digital twins, and many other IP models. From the very beginning, this platform was more oriented at the creation of databases, 3D models of industrial models, which today exist just on paper, but not in a 3D format. But there is a big difference between a drawing, an engineering drawing, and a 3D model. And no matter how many pages of drawings you have, still it cannot be compared with a 3D model. So we invented a 3D system that allows us to do it. And then we set a more ambitious task, because a 3D model can be used in mathematical modeling in industry, and we decided to perfect it. We looked at our own system from a broader perspective. And 3D model, just to remind you, describes the shape of the production, and 3D models can be simple and can be more complicated, can describe the color, the material that something is produced of. And we invented a web platform that allows to upload 3D platforms, 3D models, and the system itself evaluates the efficiency of the proposed invention in the 3D form. We understand that there is no relevant legislation, but still we can already assess the novelty of an invention by uploading a 3D model into our system. We have neural network models. We uploaded it, integrated it into our platform, and it speeded up the search, our search engine. We can compare models, the novelty of them, and we have a system of tools and a completely new type of software that allows us to look for similar inventions, similar products, and compare them. First, we do a mathematical comparison, and second, we do a neural network comparison. And owing to the use of neural network comparison, we have a conclusion, expert conclusion, on the novelty of whatever product we may think, bottle labels or engineering constructions. And the model, our platform, web platform, has proved to be very efficient because it speeds up patent expertise, patent inspections. As you all know, all patents are now assessed and evaluated virtually by hand, manually. Experts have to check lots of pages, inspect thousands of models. And of course, we are not void of mistakes. And our platform speeds up the time of assessment. Another thing, when we speak about 3D models, it's just a shape, some certain shape. But how can we create added value? How can we increase added value? When we speak about digital twins, then it comprises modeling and the calculations of gas dynamics, hydrodynamics, and we speak about calculation networks. And calculation networks is a completely separate IP object because it is done separately, and engineers used to do this network, calculation networks, manually, working on their computer, and it takes lots of time and lots of effort. And visually, it doesn't look good. But this network can be used in calculation using a whole range of parameters, and this network with these parameters are also an IP object, and then somebody wants to use this network, this object, and validate the results of its application, probably does experiments to validate the results of the calculation, and the results of these calculations are related to the 3D model. But still, these results are considered to be a separate IP project. And we just thought that if we extend or expand our platform and add on an ecosystem comprising a whole variety of IP objects, including networks, calculation networks, it would make our platform more applicable, including in different industries and different sectors of economy. And we could evaluate all sorts of inventions that appear in different industrial sectors. And just a few things to add. So our platform is fully integrated in the IP chain. And if you send us the your info on networks or on your models, then we will create a whole system of invention assessment. And thank you. So what I deduced, what I inferred from your contribution, say an engineer made a certain decision, and he does not think of the consequences of his calculations, and he doesn't consider ready to be an IP object. But having said, if he sends his calculations to your system, he has an assessment, conclusion, verification, and the system can even offer some solutions of how this invention can be commercialized. And in general, I think that engineering centers, by sending their inventions, their technical solutions to you, they can commercialize, not only patent, but also commercialize their inventions. Yes, you're absolutely right. We are just like an additional sales or distribution channel. Every invention has to be commercialized. Roscosmos, I'm sure, is ready to buy such a product from you, from Peter the Great Polytechnic University. So are you ready to buy it? Oh, well, yes, I'm ready to sign an agreement right now. Well, I'm speaking in technical terms. Well, I was listening to the presentation, and colleagues who have been working with us, they know that we are trying to invent our own internal model that meets 3 criteria. And I'm just asking, I was just thinking whether you meet our criteria of simplicity and reducing transaction costs. And when I listened to your presentation, I understood that, yes, your system meets our criteria for complex IP objects. It's a very interesting technical solution of yours, and I'm just thinking how easy it is to integrate all the technical solutions using your platform. This is something that we've been dreaming about for a long time, because construction workers very often say that quickly, efficiently, and cheaply. And this is a very good illustration of these 3 things, these 3 criteria are possible.
So probably we can have some time after that, after the session, for questions and answers. Or do you have something really very important? It's difficult to hear the speaker because he is not speaking into the microphone.
Стандарта методология, утвержденная по оценке вот этих всех формул и графики. То есть, когда Роскосмос говорит, что мы у вас купим, то есть, по факту, госкорпорация ссылается на какую-то частную формулу айтишника, который придумал интеллект. Не считаете ли вы необходимым вот эти все формулы, оценки, значит, методологии утвердить на уровне государства? Тогда будет понятно, значит, как
Да, вот сейчас...
Yes, yes. I think it's the question to some potential customers, like Natalia Belinkaya. Yeah, I think, well, just when I hear your question, I think that we sometimes confuse the internal service, or domestic service, which can make it more simple and cheaper, and well, it is in legislative things a little bit more easier. But you speak about something different. You speak about some complications. But I think that for the customers, it doesn't make much difference. And when you come to some private company, and when they have got some formula and they develop some particular formula, or they have some new invention, it's difficult to, just to prove. And it's difficult to come up to some legislative frameworks. Well, I think that with IP chain, the uploading into your platform is the source for just to upload actually the objects. But as soon as you develop some other platform, I think it will make it a little bit easier. But as soon as we have this platform, so just we can work with it. But you have got a customer, and you have got a seller, and you have got the rights. And there is some unified platform, and you can come to some standards. You can standardize it with some particular requirements. So just, yeah, and well, thinking about that, I would like to mention 2 things. I've just come back from business breakfast with Forbes, and they mentioned that if you are not forbidden to do that, you can do it. So just if you have created something and you can prove that it's new and it is useful and there is somebody who can buy it or who is eager to buy it, there are no questions. Yeah, so just go ahead and do it. Well, I think these are, well, customers' risks. And I would like to stop this discussion because as soon as you see the standard, as soon as the standard appears, then, well, just you can speak about some new protection methods, because as soon as the protection methods fall within the standard, they become the traditional or accepted protection methods. But I have got a question to Katrashenko Alexander, because we started speaking about 3D models and calculation tables. And what about the programs? What about the software and programs which are attached to this issue? So, yeah, thank you so much. I represent the University for Informational Technologies, and well, basically we deal with the information technologies. And now what we register the text of the, well, piece of literature. Well, you know that sometimes we need all these documents just to report about it, because as soon as you change a comma or as soon as you, well, introduce some new changes, you need some new certificate, and it means that you try to register a new program. So, and what is the essence of the program? It's not only about software, it's also about the computer games and about some methods of image processing. The essence, the idea is the algorithm. And as soon as we understand that the intellectual property as it is about algorithm, then we understand that we have to proceed from the text, protecting the text, to protecting the algorithm. So it sets us some particular tasks which we try to solve in the university. And now we are proceeding to IP chain. So algorithm could be written in pseudo language, just which standardize it. Then algorithm could be described in a schematic way, and then you can have some legal descriptions. Then you can verify the implementation of the algorithm in different languages with different degree of efficiency. And that is the background which can protect the intellectual property of well, software. And we are identifying the algorithm within software. So just we develop different systems of verification. We well, just classify to some existing algorithm. That is the particular main task for the, well, just for identification work. And so we write them in a OCRG format where we create the database of algorithms. And we are going to test this database, or we are going to test the results of this verification work. Then we come to the well, chain of monetization of this algorithm, because we understand that everything proceeds from ML algorithm, and then we can identify the whole chain of VAT creation or VAT development to the algorithm. So that's about almost all the products that we use now. So just well, just when we heard to when we listened to Vladimir Maslov, and he spoke about different models and about different systems and calculation programs, and then the data which Natalia spoke about, that they can be live and they can be digital and they can change. So when it comes to algorithms, so everything is brought together. So it means that you can develop some solutions which can be applied to everything, to something new, to something unique. And and as soon as you have the reference database, you can, you can intensify your identification work, right? So yes, but I think that everybody who knows, just software design as the as a science, everybody or just all experts in this field knows the work of Donald Knuth, the art of software design or art of programming. And it means that we have to protect, to give the maximum protection to the object which can be capitalized on. And but when it comes to the calculation tables, they can be different and they can lead to some different results. The same, like labor intensity or the value of algorithm and so on. We understood that just as soon as we have accumulated from 1,000 to 10,000 different algorithms, we can work out some model, some more or less reliable model to identify and to verify algorithms. And it comes to different areas like 3D modeling, like high intensity production, and even cognitive technologies. So, I think just the numbers are very similar to industrial examples, to industrial samples, because every year we register about 4,000 or 5,000 new industrial samples. So, but just if you consider the 5-time growth, then you will have the same figures like 15,000, 20,000. Yeah, and probably when you compare it to the database of 25,000 objects, it means that you can speak about something new. Yeah, but just when you think about this black box black box testing, so just you can question yourself, what is the reference database? And we don't understand what's been analyzed within the black box when it is done by some traditional agency or some traditional ministry. Yeah. So, but just when you analyze it from the new reference database, then you will have the new results and you have got the new outcomes, like, just the new qualities of the object. So, but we mentioned algorithm database, and sometimes from just from some original data, from original big data, we can squeeze some, just some some lower amount of data, but just anyway, all of them are the results of the intellectual activity. And we have got a representative of Higher School of Economics. I think that Higher School of Economics is special university, special institution, because they must be about economics, but they publish lots of papers about mathematics and IT, and they produce huge amount of databases and analytical work. Just what do you do about protecting all of that?
Thank you very much. We're not only specialized in economics. We have started specializing in physics and chemistry and biology last year, but I will speak mostly on economics and the economy, because the majority of research that we do in High School of Economics, we do in the economics and statistics, and we analyze the results, and we are very much interested in protecting the results of our intellectual research. And when I read the civil code, the relevant article on the protection of IP rights, we don't know how we can actually apply this legislation and how we can protect the results of our intellectual activity. So that's why High School of Economics is very much interested, and we are one of the co-founders of the IP chain, and we propose a service of assessing, processing, and storing the results of sociological research, and we analyze the efficiency of research, research works, the data collected, the database of respondents, and we work with our colleagues and on the algorithms of statistical data processing. We do visualization of our research works, and we publish articles and a collection of articles on statistical research, and we are going to use to upload all this data on a special web page platform, and will be a resource for researchers, for statisticians, and then there will be another function performed by this service, by this web service, for the transfer of big data and the storage of big data on statistical research. And we think that this platform will solve three tasks. First of all, it will improve communication between researchers specializing in economics and social sciences. It will increase the visibility of their research in the mass media and in business community, and it will give the senior management team of the university and other research institutions an opportunity to compare the efficiency of different research using the system of efficient contracts, and remunerates the best researchers. And in the future, we are planning to commercialize our IP products, and we will build an stock exchange of this, so to say, an intellectual stock exchange of this ideas. And I'm sure that next year we will present a full-fledged system that I'm describing to you next year. And in the framework of this IPQuorum, we will present another product on intellectual entrepreneurship during one of the sessions. And I'm looking forward to your comments and contributions. Well, as I understood your presentation, so somebody does a sociological research, and what you do, you get funding, you invest funding into this sociological research, and as history shows, sociologists do research, publish results, and that's it. And what you tried to tell us, you are saying that you analyzed a database of respondents, analyzed the efficiency of the questionnaires, the questions, and these questionnaires are IP objects. And then respondents answered the questions, and then you processed the data received, and then you visualized the data using your algorithm, and all the systems, visualization, processing, all these systems are your IP products. And I understand that you have to protect your IP rights. I think that researchers using your platform have not only a publication, but at least 5 to 7 IP objects. Each of the objects can be commercialized, can be capitalized. Yes, you are right, because usually when statistical or sociological research is published, it's published and then it gets dusted somewhere on a shelf in a library. But in our case, using our system, researchers can distribute, can disseminate the information obtained in this research. They can use it as a basis for a further research. So we're speaking about a transfer of knowledge and a very good channel of commercialization. So these IP products need a new legal protection, and they stimulate the developments of the IP markets. It's time to start moving. It's time to go forwards and to sail this ocean of intellectual property. I know that intellectual property in the intellectual property sphere, we conclude annually 4,000 deals in the IP area in Russia annually. Quite a few speakers today mentioned the following fact, that the information on the creation of IP object is placed in blockchain. I understand the essence and the message, the idea behind it, to fix the rights, intellectual property rights. Blockchain is a wonderful technology because it performs a protective function both for artistic objects and technological objects. So it's my pleasure to give the floor to Hasan Kurtuluş. Hasan Kurtuluş, co-founder and director general of ProofStack company.
Уважаемые коллеги, друзья,
and Rospatent events, Kolkova events, State Duma, and every time I appreciate it for the hospitality. Spasiba. We talk about the session topic about fast legal protection. Now legal protection means global, everything global. So if you make it fast, it should be legally binding in Russia, in Turkey, in Singapore, in other countries. But I will give you an example about the issues, so why we need this legal protection. So for example, trademark, Apple. You can search trademark and you can see who is the owner of trademark. The company, the owner, creator. The patent, you can see the touchscreen. You can search touchscreen, maybe you spend time. There are some lot of softwares, you can find the owner. And there are also patent for patentable products, but it's not visible, it's private, people working on it. But if you search Apple for copyright, the photos of Apple, who is the owner of Apple? There are 20 million results. There is no database. For patent and trademark, there is database. But for copyright, there is, internal, there are some countries that have a copyright registration office, there are internal database. But internationally, there is no database. So if you try to search who is the owner of Apple, there is no result. This means when you create, like this is an example of Apple, but it can be music, art, another image, script, scenario, you can say white paper, a lot of things, software project. What we need to do for this? When we create this one, this needs to be legally binding instantly. This means nobody see it, nobody review it. For patent, somebody should review it. But what I believe that during the presentation you will see it, blockchain is an opportunity to start global notarization. So anything patentable, also copyrightable, because it includes image, content, colors. This means a lot of project is preparing, but needs to be legally protected globally. But how we will do this? Now, physically, the government authorized notary. And when you go to notary, notary stamp it. But it's legally binding in Russia, not in Turkey, not in another country. There are also qualified authorities, some research, they say, trust authorities. This is your digital file. There's a finger hash print. This is recorded in their server. In notary, your physical file recorded in the archive of notary. But in qualified authority, it's just a hash, like cryptographic hash value recorded. So this is like a shadow. I call it mathematical shadow. Nobody see your file. So your image, your any project, any of your works, nobody see it. But the problem is, yes, there's a qualified authority in Russia too, in Turkey too, in Singapore too. But the problem is, that proof, at the end of the day, you need to use in another country. This means a lot of questions. How would you do this? How many authorities? How much does this cost to you? And if you don't know, the infringer in another country, they don't know too, and they don't scare. This means we need mutual recognition. So if this notarization system works, when you create immediately, it should be recognized immediately in other countries. Otherwise, this cannot be global protection. Well, is this possible? Yes, possible. It's already done. European Union, according to the EDAS regulation, Digital Single Market, effective since 2016. One EU qualified authority means one file recognized like legally binding in 28 EU countries. So this is the fast protection. Technology, digitalization, and mutual recognition. Without this structure, there is nothing can be fast. Like European Union, very serious organization. They make one visa, one currency. Now they make it one digital single market. But the problem is, I'm from Turkey, I live in Vietnam. How can I use this one? Yes, I can create a proof to protect my rights in Europe, but what about in other countries? We need a different technology that can be used for new global trust system. What is this new global trust system? I will compare like notary, qualified authority, and blockchain. Remember, I told you before, qualified authority, they record your hash function. Now, your hash function is recorded in millions of computers, not one server, millions of servers. This can be millions, or this can be Rosatom, Cyberbank, Singapore Central Bank, a lot of, you can arrange the numbers. This means, are you trust just the Russian authority, or you trust just the Turkish authority, or are you trust millions of computers, because nobody can delete them. And it's not just like this, also additionally, there is a new global chain that before you create something, your white paper, for example, there is another record before, and you are connected with that one. And then after you, there is another record. This all chain connected. So if you ask me, what is the feature? You know, before there is Nokia phone, there's iPhone phone. When the iPhone phone come, people say, this is okay, Nokia enough for me. But iPhone is the new things. Its applications changed. So the blockchain is the structure of this one. And now, European Union, the first EDAS regulation is 1999. And the second EDAS regulation, after 50 years, they make it one digital single market in 2016. So I want to show the time, the difference, 15 years. And now, just 1.5 years later, 2 years later, they sign an agreement, European Blockchain Partnership. They invest 80 million euro, and they have a budget for 300 billion euro. This will give you idea how will be the future. Now, I will give you the practice for this. Like, there are universities in Turkey, 3 universities. They're working with our company, Proofstack. Yeah. At the moment, they use Turkish authority because it's legally binding in Turkey. But in Europe, this is a process. So they don't prefer to use Turkish legally binding notarized document in Europe. Instead of this, they use German authority, because German authority stamp your file, notarize your file. It means 28 EU countries recognize it. So another university for Japan, they use Ethereum blockchain because they cannot take the risk. At the moment, the session topic, what is the best solution today? The best solution for Turkey is different, for Russia is different. But the future is all about blockchain, but they cannot use it now. That's why we have a hybrid solution for them, and they use it. Yeah, you know, the patentable products, we talk about a lot today. Every second, thousands of patents. And the companies, they're looking solution for today and for the future. the Turkish authority cannot be recognized by Russia if we don't do mutual recognition, or cannot be recognized by European Union, because European Union, they have their own rules. So they believe the future is blockchain. So what they do, for example, this design, the same file, they notarize with the Turkish authority, they notarize with the European Union authority, and they notarize with the Ethereum protocol. Because they believe that the blockchain can be a standard in the future. So today, 5 countries recognize it, it can be 50 countries 5 years later. So that's why they believe this, and they don't take the risk, and it's so cheap, and they use it. My final words, I come here from Turkey, and blockchain is an opportunity for Turkey, for Russia, but as long as we do mutual recognition. Already start and already happening, and this is the new global trust system for global notarization, and we need to consider like this. There is 2 steps always. First step, fast, digital, global, mutual recognition, and privacy important. So this can be happen with the blockchain. And the second, what we talk about the current system, but this current system, the authorities, but the patent authorities, trademark authorities, everything will be based on blockchain. Спасибо.
Спасибо большое. Я хотел бы подчеркнуть важную вещь.
So I would like to stress one very important idea about the essence of legal protection. International community trust. Do international communities in different countries, they do trust the system of blockchain, and this system really goes global and decentralized, which is very important, because this is a technology that actually ensures trust, and that's why new ways of IP protections work for the benefit of increasing this global trust. And the next speaker is Mikhail Bashirov. I don't know if you're here. Yes, the speaker is here. Bashirov, representing Mikhail Bashirov, managing partner of the law company Bashirov and Partners. And we will speak about piracy. And I would like to listen to your point of view on the issues that we are discussing today. New types of protection which can be used to prevent piracy. Or to prevent piracy. Yes, thank you very much. In my very short presentation, I will speak about not so much about, I will speak about the protection of intellectual property. And we can look at this problem from the following perspective. Of course, IP protection, either classical protection, classical objects, for instance, software, or new types of IP objects, which are not even mentioned in Russian legislation or in the legislation of other countries. So this protection presupposes this technological visualization. And of course, we understand that there are different types of measures to protect intellectual property, traditional ones and modern means that range from the identification of violations of IP rights to the actual protection of IP rights. And my company specializes in the protection of intellectual property rights for software. But of course, we are fully aware of all the latest developments in this sphere, and I'm sure that other companies specializing in IP protection can learn from our experience. Yes, you are absolutely right, because there is a market of software protection, but there is not yet a market for the protection of new types of technological developments, 3D models, for instance. Yes, you're right. So I will start from a couple of slides and say very briefly, tell you about the statistics provided by our international partners on the global tendencies of piracy in the sphere of software transfer. And then I will inform you very briefly about the Russian experience of combating piracy and modern approaches to combating piracy. When we speak about, so to say, the global history of the global software protection markets, this slide shows top 20 countries famous negatively for their piracy. China, nobody can compete with China when it comes to piracy, and they are the global leader. Then US comes second, then India and Russia comes fourth in this negative ranking. And if you look at the statistics from the previous years, you will see that the situation is more or less the same. In 2015, Russia ranked second. In 17 and 18, 2018, 2017, Russia ranks fourth in the world when it comes to piracy. It doesn't mean that there's less software piracy in Russia. No, it just shows that Russia probably does the same, but piracy, software piracy in other countries is going up, and China is a traditional leader in software piracy. Then identification of piracy cases. How can it be done? First and foremost, we speak about corporate piracy. For this, we need a system of monitoring of legal and illegal use of software. And first, installation, uploading, and later illegal use of pirated software. Then, second stage, license audit. When we have a tool that allows us to check license, to check the expiry dates and the existence of software licensing. And we have an agreement with our partners who does exactly the same thing, working with software vendors. And then classical approaches to combating piracy, police measures or police raids, which are done quite regularly on a regular basis. So a whole range of measures to be used. Very briefly, I will tell you about legal tools that can be applied to pirates. So the main legal tools are two. Actually, when we speak about civil code, this is point 3 of the law of the civil code on piracy, when we can fine those who use illegally this software products. And this is one tool, and the other tool is large-scale piracy. And according to 146 article of our legislation, the fine can be up to 1 million rubles. So, but for pirates, for corporate piracy, 1 million ruble is not a large sum of money. Because the actual piracy effect is much higher in financial terms than the fine imposed by this provision of this legislation. Okay, international practice, international experience. There are three most popular arguments given by companies were accused of piracy. And then solutions. I will speak about the solutions and court decisions. So the first argument, we only stored this pirate program. We didn't really use it. That's why we cannot be fined. But this argument really didn't work. It doesn't work because if somebody uploads this pirate software, and if somebody doesn't use it, then this argument does not work. And this is considered to be a breach of IP legislation. And all court cases find these companies guilty. Second argument. the company itself doesn't know that its employees uploaded or even used pirate legislation. So the company is not to be blamed. Employees are to be blamed. But of course, in our legislation, there is a certain provision that says that if in a local intranet of the company we find an illegally uploaded software, no matter who does it, then the company is found guilty, is guilty of the breach. And third argument, pirate software was installed on computers which are not really registered, which do not legally belong to the company. For instance, when computers are in the intranet of the company, but officially is not registered as belonging to them. Nevertheless, if we find pirate software installed on these computers, it's still a breach. It's a breach of legislation. So, what is the accent? So, software program, if it is pirate software program, no matter what kind of software program it is, either for 3D models or for 2D models, whatever program is uploaded illegally, it doesn't matter. Then the case can be taken to court, and intellectual property rights of the developers of the software can be protected. So a digital copy of an IP object should be protected as well. So I remember we took part in this one particular event, and you mentioned that it's very interesting how your system works, protecting the samples of plants. And if we use some marks, some chips, in growing, when these plants are grown, then we can protect intellectual property rights in plant cell editing. And last point that I wanted to say, when we speak about piracy of mass software, then I should say that there are fewer and fewer cases of this mass software piracy, and I know that our partners actually performed a number of raids in the year 2000 and early 2000, and there were lots of cases when cases were taken to court. And when it comes down to more complicated software used in gas and hydrodynamics and other complicated spheres, then the piracy cases have been going up. The number of piracy cases have been going up. But at the same time, intellectual property rights holders, they have efficient tools of protecting their rights, combating piracy, and of course taking these cases, these matters to court. And finally, there's another tendency, the following one: when corporate pirates of today, even though they continue uploading illegally software, when intellectual property rights contact these pirates, they try to avoid court decisions, and they prefer to legalize, so to say, to pay for the license and use the same software, but this time legally. And this is a positive tendency. And yesterday at a press conference, there were one of the speakers was a representative of the Intellectual Property Rights Court, and we were discussing ways and means to protect IP rights. And when the press conference was over, somebody said that whatever argument is pertaining to intellectual property rights, all matters are taken to court. And the representative of the IP court said, no, this is not right. There are more cases when, more and more cases when we find a compromise, when companies find a compromise. This is a very interesting example, especially when we think about 3D models and the violation, the breach of intellectual property rights by companies. This is a separate case, quite different from IP violations in music.
So, colleagues, we have spoken about different types of objects, about the musical objects, about the issues of legal protection, and we have identified that, yes, there are some legal mechanisms to protect the intellectual property rights, and our new tricks and loopholes about some new ways of protection. Yeah, so just they also make sense. And probably to finalize our talk, we address Sergei Vladimirovich, Sergei Prishepny, sorry, from the intellectual expert on intellectual property rights from the expert center. So because every time when we come to protecting intellectual property rights, we come to some legislation. So just we have to bridge the gap between the model, like the model of nuclear power station, and some patents and the legislation. And we have to come to the standard regulations on protection of rights. And I think that just we have the Russian Expert Center as the main agent which accumulates all these stories about protection of intellectual property rights and copyrights. Thank you. Yes, I've got the presentation, and I would like to speak on the methods of enhancement of intellectual property rights program for the rights holders who work in cartoon industry. You know that our cartoon movie studio, Soyuz Multfilm, so they create different characters, and and they have got the patents on different characters, and they certainly must use the different regulations on their right protections. And the first company which decided to patent the characters was Disney company, and they just patented their characters. And their rights are actual even now. Our companies also decided to patent the characters, and you can see the pictures of those characters which were patented. As soon as the company files the patent on the character, they also protect the rights on the names of the film. So it's a kind of combined trademark, which includes not only the character but the name of the movie, cartoon movie as well. So just all the names of the popular cartoons are protected. So the major consumers, or just the target audience for consuming these objects, are children and teenagers. And then we can see some infringements. But when companies file the applications, they identify what they are going to protect. So I have identified 4 classes of different things which are to be protected. So, and which deal with teenagers and children. They are just toys, confectionery and cakes. They are different things to wear, and they are different entertainment objects. And so just we can take whatever way we like. But as soon as our cartoon character is changed, then we can apply to the legislation to exercise our right to protect the trademark and to protect the character.
Знаете, здесь, мне кажется, из этого...
So thank you. I think that this case gives us a very simple mechanism. If you have got something, character, let's say character, or just whatever you like, you can work out a regime on trademark protection. You can make a title which is to be protected. You can make an industrial sample. And I think that cartoon characters are very, very suitable for this. So just they can become a very good background for producing something more. So, but you can choose whatever regime you like, which suits the market objectives, marketing objectives much better. So you analyze the new object, and you understand what characteristics are to be selected to promote or just to produce something more out of the object that you have selected. So I think that we have talked about everything, and we are, actually have made use of all the time that just was within our disposal. So if you have any questions to the speakers, yes, just we can ask something, or we can, just sum it up, saying that, the creativity field and this intellectual property rights protection field are very important for further market development, and we have got some good instruments to protect trademarks, and we have got some new technologies like IP chain, like artificial intelligence, and so on. So we have got some traditional roots and traditional principles and traditional rules to protect the rights, and they just have been existing for quite a time, and they were very they was the background in pre-digital epoch. So we can use different mechanisms to protect the rights, and we can see bridging of non-digital and digital technologies in this new digital era.